5 seconds to go. Start. We may note here that during the course of the hearing of submissions of the learned senior counsel appearing for the petitioners, he attempted to assail the validity of certain provisions of the J&K Reorganization Act. Therefore, we pointed out to him that there is no challenge incorporated in the present writ petition to the constitutional validity of any of the provisions of the J&K Reorganization Act. The initial response of the senior counsel was that he does not wish to challenge the provisions. However, subsequently he submitted that the challenge to the relevant provisions of the J&K Reorganization Act is implicit in this writ petition. There cannot be any doubt that when a party wants to challenge the constitutional validity of a statute, he must plead in detail the grounds on which the validity of the statute is sought to be challenged. In absence of the specific pleadings to that effect, court cannot go into the issue of the validity of statutory provisions. The constitutional courts cannot interfere with the law made by the legislature unless it is specifically challenged by incorporating specific grounds of challenge in the pleadings. The reason is that there is always a presumption of the constitutionality of laws. The burden is always on the person alleging unconstitutionality to prove it. For that purpose, the challenge has to be specifically pleaded by setting out the specific grounds on which the challenge is made. A constitutional court cannot casually interfere with the legislation made by a competent legislature only by drawing an inference from the pleadings that the challenge to the validity is implicit. The state gets a proper opportunity to defend the legislation only if the state is made aware of the grounds on which the legislation is sought to be challenged. Though an opportunity was available to the petitioners to challenge the provisions of the J&K Reorganization Act, the petitioners have chosen not to do so. We may also note here that the petitioners are also not questioning the 2019 presidential order and the said declaration. Therefore, we will have to proceed on the footing that the 2019 presidential order, the said declaration, and the provisions of the J&K Reorganization Act are valid. It is in this context that the submissions made across the bar will have to be appreciated. The Constitution makes a clear distinction between the states and union territories, as can be seen from Article 1 and the first schedule. Part 5 of the Constitution deals with the Union. Chapter 2nd of Part 5 deals with Parliament. Part 6 deals with the states. Chapter 3rd of Part 6 deals with the state legislature. Part 8 of the Constitution independently deals with the union territories. Article 3 provides that Parliament may, by law, from new states and alter the areas, boundaries, or names of the existing states. The explanation first provides that in clauses A to E of Article 3, a state includes union territory. Thus, explanation first makes it amply clear that the power of Parliament under Clause A of Article 3 to make a law to form a new state or to alter a boundary of a state includes a power to make a law to form a new union territory. Explanation second clarifies that the power conferred by Clause A on Parliament to enact the law to form a new state includes a power to form a union territory by uniting parts of any state or union territory to any other state or union territory. Clause 1 of Article 4 provides that any law made by Parliament as provided in Article 3 shall contain such provisions for the amendment of the first schedule containing the list of states and union territories and fourth schedule containing allocation of seats in the Council of States as may be necessary for the purposes of giving effect to the provisions of the law. Stop.